Okay, homestead property in Florida, very unique area of law, very unique circumstance that is great for a lot of reasons, but can be challenging, can be difficult if you don't anticipate that when you pass away and as for inheritance purposes. So first, what is a homestead property in Florida? Basically, it's your primary residence. It's where you live the majority of the year. You pay taxes. It's in your name. There's some size requirements. Most of those probably aren't going to apply to the majority of people, but it's your primary. It's your primary residence where you live the majority of the year. Now, when you pass away, right? If you're married, that homestead goes automatically to your surviving spouse. Now, in most cases, you and the spouse are going to be on title. And so if the deed says as husband and wife, when the husband passes away, the wife inherits the property automatically. You don't have to do anything, right? Or vice versa, wife passes away, it goes to the husband. But and where we see this a lot of times is maybe there was a deed that was done in the past and for whatever reason it didn't list both spouses on there. Maybe it just said, just listed the husband for whatever reason. Or maybe this is a house that was purchased before the marriage. So, the husband bought it while he was single, and so the house says, John, a single man, and they never put the wife on there. Well, in both of those cases, both spouses aren't on the title, or bought it as a single person, so the other spouse is not on there. Probate's going to be necessary, and you can leave the homestead property via a will, but there are certain limitations. For example, if you have minor children, you can't disinherit your minor children. They're going to be entitled to a part of the house. If you're married, you can't disinherit your spouse completely. So let's say that it's a second marriage, you and your spouse agree, nope, leave, husband, you leave the house to your kids. I've got another house, I'll leave it to my kids. You can't do that just via will. You might be able to do it with a prenuptial agreement and some additional planning, but you can't just say that in a will. And so a lot of the times where we see conflicts at is where husband and wife are married, and let's say husband has adult children from a previous marriage, or just has adult kids that are not kids of his current spouse. He's the only person on title, so that the title just says John Smith, a single man, or whatnot. His wife's not on there. He now passes away. The wife wants to put the house in her name. Unfortunately, though, Florida law is going to only give her two options. Because she wasn't on title, and because there was no will that left the property to her, and because he had adult children, her options are going to be she can keep 50% of the house and split the 50% with the kids, so that she owns 50% outright and the kids from him own the house 50% outright. Or she can choose what's called a life estate, where she basically just says, I get to live in the house, I can rent the house, but I don't get to sell the house. I'm really not the owner. I'm kind of a life tenant living in the house until I pass away. And then when I pass away, the house goes to the kids. Neither options most people are very happy about. So, but unfortunately, that's really the only options there are, unless the kids and the spouse work out something. Most of the times they don't want to work out anything. So you want to plan for that. So if you've got kids, from a previous marriage and you're married, make sure that your spouse is on title. Probably number one would be the first thing, but then plan for that. Put it in a trust. At least plan for it via a will. See what options are available, because homestead can be great as far as protecting you from creditors and protecting you from liabilities and different things like that. But as far as inheritance, there can be a lot of issues.